Might go to Section 18C of the Racial Discrimination Act, first of all. A question for you, Gideon. We've seen in the last 24 hours the cause célèbre, that is the case brought against three QUT students about what they said on social media following the fact that they were not allowed access to an Indigenous students only computer room, being thrown out of court. Does this not suggest that it's not the words insult and offend that are the problem, but the mechanics and the operation of the Racial Discrimination Act, the fact that it took 3 years for this to be resolved, rather than that what they were saying, which was found not to be offensive at all according to the Act?
Well, Jim, the answer is it's both. The fact that this came before the courts in the way that it did and the mechanics, as you described, occurred is a result of the fact that this cause of action existed and that the 18C of the Racial Discrimination Act makes it unlawful to insult or offend somebody. I'm delighted that the Federal Circuit Court has thrown out this vexatious, Kafkaesque case, but we need to be asking ourselves how we got to this situation to begin with. Why is it that 3 university students who did nothing more than engage in a bit of Facebook banter, which, by the way, could not be remotely construed as racist, were dragged before the courts for 3.5 years, were sued for $250,000, had their names dragged through the mud, were put through the anguish of very public and lengthy legal proceedings, and are now thousands of dollars in the hole in legal fees? I think this, more than anything else, and there are a few cases going on right now concerning 18C, but this case, more than anything else, shows that this law has to be reformed, and reformed now.
Ben Oaquist, we are now seeing increasing pressure from not just the Liberal backbench, not just the senators who all signed on to a private member's bill seeking to have 18C amended. We're now seeing yet another state branch of the Liberal Party, in this case Tasmania, and unanimously calling for those words to be removed from the Racial Discrimination Act. Malcolm Turnbull is having nothing of it at the moment, but do you think that he is being forced to a position where he will have to cave into his backbench, given that obviously support for such a move is so widespread?
It is interesting, isn't it? Because you remember that Tony Abbott got into the exact same problem on the other side of the debate. He had a backbench revolt that stopped him proceeding with repealing 18C. So Turnbull's in this difficult position. He's damned if he does and he's damned if he doesn't. Because I think once there's a proposition on the table again to repeal it, the other argument will well up. And it's worth remembering it was his own backbench that stopped Tony Abbott repealing 18C. There are obviously some process issues. This case took too long to be resolved in the courts, and that needed to be addressed. But you've got to remember that for 18C, there's an 18D, essentially a public interest defence that can be used. There's very few cases that are brought before the courts. So maybe an inquiry is a good option to look at free speech issues in general. Because, of course, free speech is not absolute. We do put restrictions on it in all sorts of places and in all sorts of ways. And limiting hate speech is one of those that we use in Australia. And in an era where we've got kind of race-infused politics, not just in Australia but around the world, Trump, Pauline Hanson, got to tread very, very carefully in this area. We've got a largely tolerant, a multiculturally harmonious society, and we want to keep it that way in Australia, but it requires effort and good work and some restraint on absolute freedoms. And of course, that's what 18C has been designed to do. And in many places, it's worked well. And of course, we're focused on one case that apparently hasn't worked well, but you don't want to chuck the baby out with the bathwater. So maybe an inquiry that looks at free speech overall is not a bad way to go. But we don't want a situation where we fuel more race hate speech in Australia, especially at a time when we're seeing Pauline Hanson on the rise.
Gideon, Ben's certainly right about that in sense of not wanting to fuel race hate speech. I would note that important constituencies, many of whom vote Liberal, for example, within the Jewish community, are adamantly opposed to any kind of change at all, and threatening to let the government know in no uncertain terms Do you think then that an inquiry perhaps into this is a good first step? Because the other thing that Malcolm Turnbull doesn't need is to have this constant revolt, this rolling revolt on his hands from the rank and file or the backbench.
Well, look, as a Jewish person myself, I can certainly tell you that I support immediate reform and change to that particular law. But on the issue of hate speech, I absolutely agree that there should be free speech. There are acceptable limits to free speech, for example, limits that currently exist on incitement to violence. Defamation law provides certain limits on free speech, but I don't think that it should be unlawful to insult or offend somebody. So this is I think that there is a wide community acceptance now that certain cases before the courts have gone too far, and that those two words in particular are a modest and sensible way of reforming a law that is having some very perverse outcomes. Just to turn quickly to the Bill Lee case as an example of another case which is causing huge community concern. This is a person who is dragged before a government agency because of publishing a cartoon. Now, Bill Lee's cartoon was confronting. It made people uncomfortable. A lot of people didn't like it, and that's their prerogative. But I don't think that you could call it hate speech. It was commentary on a very, very serious societal issue. And when we're getting to the stage where shutting down and opposing viewpoints and debates, not by other arguments, not by engaging in democratic debate, but through the courts, I think that's a very, very dangerous development. And I think that is another example of where the foot law needs reform.